put it on the groups. Okay. Hello everyone, this is Sanchita Ain. I'm an advocate on record at the Supreme Court of India. So thanks everyone for joining us today. We will be quickly starting. Right. So the topic of discussion today is, are you ready to argue before the Supreme Court? Or is it too early? Let's see. When did I start arguing? So I had told this even yesterday that my senior was not around, and I went to seek a Passover when the judge asked me to argue. So I was, he made me comfortable and all of that happened. But that was how I accidentally started arguing. I didn't intend to start arguing when I was asked to, right? So initially, you don't get too many opportunities to argue. So initially, it's only when your senior is not available, because ultimately the client is paying your senior to argue. So even if it's not a senior advocate, even if it's a lawyer of a certain years of experience with whom you're working, the client has paid that person to argue, and therefore they would expect them to argue. Therefore, your opportunities get very limited when you are working as a junior, right? So it's only when they are not available, and particularly in the Supreme Court, it's only in extreme cases when you get these kind of opportunities when your senior is busy in the court and the judge insists that you need to argue. That's how you start arguing, right? So why do law students or young lawyers have this question in mind? Is it too early? Something, even people are reluctant to say, oh, I want to practice in the Supreme Court, right? Because I was just telling Sakshi that I keep asking this question every time, why have you come to attend this webinar? But people don't say this, that, I want to practice in the Supreme Court and therefore I'm attending this webinar. They do have doubts and questions in mind that originates somewhere. So we are going to look at that concern today, where it originates from. Why do people hesitate to even say this, that yes, we want to practice in this, right? Okay, so the traditional view is that you need to first start practicing in the district court, then the high court, and only then you should think of setting up a practice before the Supreme Court. In each webinar, I'm asked this question: should we start in the district court first? Should we gain some experience in the district court and then to move on to high court and then the Supreme Court? This is exactly the question that keeps coming up. It's because there's a traditional view that says so, right? So let's first break the mental block, then we'll see why we have this traditional view. But first, let's look at why do people have this in mind, right? Okay, how do we break it? Let's look at the names of these courts carefully. Supreme Court. When you hear the word Supreme Court or when you read it aloud, what comes to mind? AOR exam, we'll be doing a separate workshop on how to crack AOR exam, but I will include that, Mayuri, in this session as well, right? So Farhad says, what comes to mind when you hear the word Supreme Court is last court. So just look at how you interpret the term. What's the connotation in your mind? Is it something like superior court? Or is it just like last court? Yeah. So sometimes when you have these kind of views that you need to first start your practice in the Supreme Court, such views originate from this connotation that it's a superior court and therefore you need to start from an inferior court. But that's not the case. There's no hierarchy as such. There's hierarchy in the sense that you have a court which is the court of last resort. But that does not mean that you need something extra to practice there. You need a different skill set. And there's no hierarchy in those skill sets. So, for example, when you are practicing in the district court, say you're doing criminal trials, that requires a specific skill set, cross-examination, etc., how you argue on charges, etc., right? When you're practicing in the Supreme Court, it requires a separate skill set altogether. So there's no hierarchy there. It's a non-hierarchical difference. Mayuri says one should be very good at interpreting law, reading the law, etc. comes to mind. Okay, that's good. Great. And when you hear the term High Court, right? So again, there is a connotation that it is higher than something, right? And therefore, people end up thinking, even if they don't know, they haven't heard this elsewhere, that you first need to practice in district court, people tend to think, oh, maybe I should start with district court because Supreme Court is a big deal, right? That's what happens. Okay, now if that is what happens, then we see that it's more or less an artificial distinction that we can get rid of. We can get over this. So now, to what extent is this view correct? See, the traditional view that we have, that you need to first start with the trial court, to some extent made sense in earlier days when you didn't have many opportunities in the Supreme Court, for young lawyers especially. So even if a young lawyer was working under a senior, they were not paid as much, and and then you had to establish your own practice. For that, you didn't have much scope. Also, because the number of matters that you reach Supreme Court were not as many as it is today. You have all sorts of matters. You have corporate matters. You have this same matter going again and again before the Supreme Court. So you have several rounds of it. So somebody goes against the interim order first, right? Suppose an FIR is registered and the accused moves the High Court under Section 482 CRPC for quashing of the FIR. The High Court dismisses it. They move to the Supreme Court. Then trial happens. Even before the trial, order on charge, again, they move to High Court and then Supreme Court. So in this manner, there's several rounds of litigation for just one matter, right? And that's why you have so many opportunities. We just look at how young lawyers these days get to work in the Supreme Court. There's so many roles that you can play. Okay, so do you become a better lawyer? That's another question, right? One thing is whether you have opportunities. That's sorted. You do have enough opportunities. Young lawyers have enough opportunities in the Supreme Court to start their practice. As juniors of AOs, as juniors of senior advocates, there are other lawyers involved as well. We look at it. So in that case, you do have sufficient opportunities, even if you're a fresher, no doubt about it. But do you become a better lawyer? Some people say you need to have a kind of foundation that only trial court can provide, right? Because Supreme Court is not examining witnesses. Supreme Court is only concerned with primarily questions of law, substantial questions of law. It can look into questions of fact, but then again, it's based on a legal position. So if that be so, isn't it just different from a trial court? How is it that working in a trial court will make you a better lawyer? To some extent, it can, and I'll tell you how. Right? I'll tell you that also, how it can make you a better lawyer. And then we'll see how you can balance and then make your own decision, right? I'm not going to suggest that, you should do, this is what you should be doing. So when you're practicing before the trial court, you obviously are dealing with procedures every day. The kind of procedures you don't have to deal with when you are practicing in the Supreme Court, right? So you need to know CPC, etc., but you don't deal with it every day. You do get some matters where you will need to refer to it, say CRPC, etc. But then you are not looking at the practical aspects of it in a manner as the trial lawyer is doing. Therefore, you'll find sometimes trial lawyers can tell you certain points that are not there in the book, even in the reference books or in the cases dealing with procedural law. They know it because they have been to police stations, they have seen how things work, etc. And therefore, they are in a better position to point that out, that this FIR number had to be written in this Caesar memo, etc. Right? Which you may not know because it's a practical kind of knowledge that only trial court lawyer will have. But even if that be so, it would have been argued at some point. So you get to know that when you read the judgment. You get to know the contentions of the your client, the counsel, when you're reading those judgments, or when you're reading the petition that was moved before the High Court. So you get to know those arguments, and then of course you may have to look into it further, find out how things work, etc. And that's how you learn. So it can never happen, whichever court you start from, it can never happen that you already know everything. So you have to learn wherever you are, whatever you are doing. You get to learn more. You may get, so suppose you start with Supreme Court, obviously you know Supreme Court rules, then you know how it works there, etc. So then that becomes your, in a way, battlefield, and you know the rules of the game in the Supreme Court. That suffices mostly, and if you need to know further, then these are the tools you use to know, and you get to know eventually, right? So, but having said that, I have seen some lawyers who, like I heard, so there was one instance when I would say a trial court lawyer really made it work, and that was when I heard Justice Jaspal Singh. So Justice Jaspal Singh, a retired High Court judge of Delhi High Court, right? So he must have been a judge and heard trial court matters, etc. Right? So he was not a practicing advocate. He was must be a civil judge, etc. Right? So he knew, he has even written a book on IPC. So he understood the law very well. And therefore, when he was arguing, he brought out certain points that nobody else would have. So to that extent, it happens. But the point is that you get those kind of cases are not so many in number that you should. And now let's look at why you may not even start from the trial court. Let's look at that aspect as well. We have now covered what advantage you will have if you start from the trial court, right? So as I was telling you, it's different skill sets altogether for different courts. So even the original jurisdiction, there is no match. The original jurisdiction of Supreme Court is either between states, center and states, etc. And or writ jurisdiction, violation of rights, something that trial court lawyer doesn't have to deal with. So if you're interested in doing constitutional law matters, then of course you won't start from the trial court, right? It can't help you, even if you start from the trial court. Okay, so now let's look at the career trajectories of some of the sitting and former judges to understand where they started from, okay? Okay, so let's look at Justice Nariman, because he was elevated. Senior Counsel, Supreme Court of India, was made Senior Counsel, etc. He has practiced in New York, right? Okay, let's look at Justice UU Lalit. Born in so-and-so, practiced in the High Court of Bombay, right? Shifted his, till 85, shifted his practice to Delhi in 86. Designated as senior advocate in 2004. So something interesting about Justice Lalit. So Justice Lalit became an AOR, I'll tell you which year. Right, 92, okay? So 92, he became the AOR and he was designated in 2004. But he established a very flourishing career as an arguing counsel as well. So he would get briefed by other counsels to argue their matters, even those matters that he had not filed himself, right? So you'll see none of these judges had started their practice from the trial court. How to start career in international law, that's not within the purview of today's webinar, but hopefully, okay. Right. Another reason why you need to start early, you need to start arguing matters early in the Supreme Court would be because it takes time to build up a practice. In any court, it takes time. So whether you start from trial court or you start from high court and then move to Supreme Court, when you are establishing a practice or building up a practice in the Supreme Court, it will take you that many years again to establish a practice there. Okay. Now, and the question that so many law students would be having is, can you start arguing before the Supreme Court right after college? Some people have this impression you cannot, etc. So let's see if you can. So during the first year of your practice, which is immediately after your enrollment, you're allowed to only mention matters. And what is mentioning? Mentioning means that if you are seeking adjournment or you are seeking more time to file something, etc., then you mention the matter before it's called out, or you mention it on a day when it's not listed. So mentioning you can do only just when the court is sitting before the matters are called out. You need to mention your matters, right? So just that can be done by, and there are rules pertaining to that sometimes, and they keep getting changed. So you need to know before whom you need to mention which matter. If it's for urgent listing, then before whom do you mention? If it's only for filing a rejoinder, etc., then before whom? So then you mention it before the bench with whom the matter is, right? Okay. Is there any other bar? No, there's not the bar. So after 1 year, you can argue even during effective hearings. Okay, this is a point that I was trying to make. At present, there are only 2,777 AORs in the Supreme Court. Okay. And do you know how many advocates have been designated as senior advocate by the Supreme Court so far? Any guesses? The screen is not visible, is it? Are you not able to see the? Okay. Okay, now you can. Okay, so senior. So there are total 2,777 after last year's result. It's 2,777. Okay, 𝘠𝘕𝗓 says maybe around 600 senior advocates. Let's see. Let's see, 𝘠𝘕𝗓. 416. Okay. Till date, only 416 advocates have been designated as senior advocates by the Supreme Court. So everyone wants to be a senior advocate, and yet there are only 416. Now let's see how it works. So now you have 2,777 and you have 416. So only these many lawyers. But when you walk into the Supreme Court, you realize there's so many lawyers, right? You don't have space to keep your foot in any courtroom. So in that case, do you think only senior advocates and AORs are arguing for the Supreme Court? No. Now, there are some advocates who start arguing before the Supreme Court quite early. They have a plan, and I'm going to talk about why they do this, okay? Because it's important for you to understand that this is in the career trajectory that you can have and you can aspire for. There are many advocates who aspire to be senior advocates, and they don't want to become a drafting counsel. They don't want to sit for AOR exams. They don't want to file. I mean, there could be various reasons for it. It's because it's a cumbersome process. They don't want to engage in it, or it could be this. Let's look at the Supreme Court guidelines to regulate conferment of designation of senior advocates. Okay, it's 2018 guidelines. Here we are. Okay, this is the committee. Let's look at the points. So number of years of practice, you get 20 points. Judgments, reported and unreported, which indicate the legal formulations advanced by the advocate concerned in the course of the proceedings of the case. Now tell me who is going to have more points here. Pro bono work done by the advocate, domain expertise, etc., etc. So when the question is judgments that would indicate your legal formulations in the course of the proceedings, then who is more likely to be noticed is the question here, right? Therefore, there are lawyers, and I will take you to the list of senior advocates also, so that you can see who gets designated. So here's in the remarks section, you will find retired judge, advocate, and advocate on record. So let me show you how many advocate on records make it to the list. So everyone wants to become an advocate on record, but let's see. There are 29 advocates on record out of 400, whatever number I told you, right? So whereas the rest are either retired judges or advocates, mostly advocates. I'll tell you how many, right? So 171 including AORs, and then you can deduct 29 from it. So you realize mostly advocates, and these advocates would be arguing counsels, right? So that's the reason why many people, many advocates aspire to be arguing counsels and not lawyers. There are, of course, I told you, I gave you example of Justice Uri Lalit. He was an AOR, but he became a good arguing counsel as well. That's how you get noticed, and that's how there is a chance of you being elevated or you being designated first as a senior advocate. So that's why they are advocates, and these advocates start very early. So you don't really have, of course, you need that kind of training as well to understand. You just can't start all of a sudden. Firstly, you won't have matters, and secondly, you won't know the practice and procedure so well, or the etiquettes, soft skills, etc. So you, of course, can take a while to understand, so you can work as a junior, and then once you pick it up, you start getting your own matters, and that's how you start arguing. Okay, so why would anybody engage you as an arguing counsel? So I told you there are advocates who are not advocate on records, advocates on record. They don't want to become advocates on record, and yet they are being briefed. They are being, I say briefed, I mean they are being asked to argue. They are being told that they are being instructed by an advocate on record or by another advocate, and told that this is what you need to say, etc. This is called briefing, right? So once they're briefed, then they argue, but they can always give it their own spin, etc. So that's the job of arguing counsel in the Supreme Court. So now tell me, why would anybody engage you as an arguing counsel? Because somebody else is working on the matter, preparing the brief, and then you are being briefed. Then why? There has to be something about you that you will be sought after to argue the case, and not somebody else. Why not somebody else? Why would they engage you? They'll engage you only if they know that you're good. And how will they know you're good? They'll know you're good only if you've argued important matters. And to get important matters, you need to start early. Right? So even if you get 1 or 2 important matters, there's no guarantee that you will continue to get important matters, because there's so many arguing counsels, and all are most of them will be competent, right? Those who are getting matters to argue, they would become competent in some manner. So therefore, it takes time to build confidence, and therefore you need to start early. But then the question, we come back to the same question. Why do people still say that you should first learn district court practice, high court practice, and then go to the Supreme Court? right? Why do people say that? That's because there are instances when some lawyers, and you would have seen the BCI resolution or SCBA resolution, I don't remember which resolution it was. Even BCI tried to amend its rule and there was a stay, and then I think it came up with a resolution. I think BCI came up with a resolution in 2019 that this should be a requirement. So there's again and again this effort being made that there should be a mandatory requirement to practice in district court or high court. Why? So if you just know why, then you can also make effort to remove that why. That's because some lawyers do not have adequate understanding of practice, procedure, and etiquette followed in the Supreme Court. That's it. Some lawyers come to argue. They do not visit Supreme Court regularly. So when they come to argue, then they obviously leave a bad impression. And there are instances when judges have asked, have you come from these or that? Right? So that would happen even if you are not well prepared, it would leave a bad impression, right? And this will happen even if a lawyer has many, many years of experience in any district court. Even then, when he goes to Supreme Court, if he does not know the practice and procedure of the Supreme Court, he'll face the same problem. So that really doesn't help you in getting to know the skill sets that are required in the Supreme Court for practicing in the Supreme Court, right? So whenever you start, it is going to take a while to get used to it and then to get better at it, right? So this is another question I would want to leave you with. If it was necessary to practice in the district court or high court to build up a practice in Supreme Court, why would that not be a requirement for becoming an EOR? That's not a requirement. The requirement is 4 years of practice and 1 year under an EOR. And what are the subjects that you need to prepare for your exam? Somebody asked me this question, and why am I pointing this out is because this is all you're expected to know for practicing in the Supreme Court. Having said that, when I say this is all you need to know, doesn't mean that these are small things. Practice and procedure, not just Supreme Court rules, but also practices that are not written in those rules, right? That you only get to know once you're there, and you get to know once. There's so many things that are there in certain notifications. You need to be updated about it, etc. Right? So that's practice and procedure. Drafting, you don't just need to know the formats, you need to have the skills also. So even when you are only an arguing counsel, you need to know. You need to know that in a draft, which is a good draft and which is not a good draft, what works and what does not work. So you need that much of basic skills, even when you are not going to draft, right? And sometimes you will get some drafting work. You're not going to refuse that, right? If you're a lawyer in the Supreme Court, people will just know you as a lawyer in Supreme Court. No one will think, oh, you are an arguing counsel, I don't want to give you. You don't want to reduce your work, right? So you will take up some drafting. It will only help you to hone your skills further. It will make you a better lawyer, and therefore you would want to take drafting. But for that, you need to develop your drafting skills as well, right? Professional ethics, again, I said there are certain soft skills. And also you don't want a contempt notice to be issued against you. So you need to know if an AOR does not appear in his own matter, then what happens? So there are cases where contempt notices were issued. So you need to know all of this, right? And then leading cases. Leading cases does not mean just knowing, yeah, party in person, they can appear directly. Yes, of course they can. Leading cases, you need to know how to interpret it as well. So leading cases does not mean the way you read those cases when you're preparing for your exams in law school. That's different. That's very different from what they're expecting you, from what they expect you when you're writing a your exam, and for that matter, when you're practicing. Right? So there is a gap that needs to be bridged, but that does not mean that practicing in the in the district court will bridge that gap. Whenever you start at Supreme Court, you need to bridge that gap yourself, or you need to do something about it, right? So, and you can do that even when you are in law school. The reason why we are doing this is because so that you can get those, acquire those skills right now. Wherever you are, whatever you are doing, you can acquire these skills now, right? So this is what you need to know or have. So it has got nothing to do with this record or high court practice. This much you understood. Now tell me then, why is it expected that you should know all this or you should have these skills? Because this is, the expectations a little higher when it comes to Supreme Court. In trial court, etc., it's okay to not know something, but in Supreme Court, the expectation becomes a little higher. The expectation is higher, this much I'll tell you. Why? Because lawyers and judges in Supreme Court are not used to seeing. I told you, in trial courts, you get to see, people, lawyers who do not know much about something and they just come and stand, but they're blank, etc. But so in Supreme Court, none of the judges, none of the lawyers are not used to seeing something of that sort. Most of the arguing counsels have been there for a while. Having said that, everyone has a first rank, right? So even though so that's what happens when you enter the Supreme Court, even as an intern, you see everyone so confident, so much brimming with energy, as if they have been there since ever. That's the impression you get. But everyone had a first time, so that kind of may give you some, the sooner it is, the more concession you're likely to get from the judges. So the sooner you start arguing, more concession you'll get, because the judge is not expecting so much from you because of your age. So age can be an advantage. Till a certain age, you get that advantage, and therefore it's again preferable to start learning when you are of that age. After a certain age, it becomes embarrassing for you, and the judge is also not being that supportive. So judges do support. They encourage junior counsels to argue. Particularly these days, they have noticed that there are many junior counsels who are very reluctant to argue. They may never be able to set up their independent practice. That's how complacent they have become. So the system has not, so they're trying really hard to break that and to make the junior counsels argue. So if that is what is happening, then I don't think that it's ever too early to start arguing the Supreme Court. All you need is willingness to acquire those skills that are needed for the Supreme Court practice, willingness to prepare when a brief comes to you. That's all is necessary. It's never too early, right? That's it, guys. So I'm willing to take questions. As per these, which article would be considered published? Sorry, I didn't get you, Ayushi. I can unmute you if you want to ask the question. Okay, let me stop sharing first. Yeah, so if a person can appear directly without any precondition, isn't it a bit of an anomaly that an advocate has to go through? Just wanted to get a view. Okay, so the thing is, you do not want to curtail the right of a person to appear in person or to file in person. So in fact, to argue in person, you need to file an application, right? But just because you need to balance the rights of a party who for some reason cannot engage an advocate, therefore you have the provision where petitioner in person can also file. But there is a provision of AOR, mandatorily you are required to engage an AOR to file the petitions and no other advocate can file it. It's because it's to be done in a certain manner, and it's kind of assumed that since an AOR has gone through the exam and is prepared for that exam, he has those skills that are necessary. He has the knowledge that is necessary to file it in a proper manner. They're very, very particular about the kind of defects, etc. I mean, formatting has to be perfect. Everything has to be perfect. So if you do not know, it's very difficult to get the defects removed. It won't be good for your client as well, because it may take even months for you to remove the defects if you do not know, right? Varun, thank you so much. Thank you. Good, you liked it. Any questions? Okay, Kusum, I'm unmuting you again. Please go ahead. Kusum, you can, yeah, sorry. Yes, please.
हाँ जी मैम, थैंक यू सो मच, वेरी इंफॉर्मेटिव सेशन। जितनी भी हेजिटेशंस होती हैं उन सबको आपने क्लियर किया है। जस्ट कि जनरल एक हेजिटेशन की और सजेशन भी रहता है कि आप डिस्ट्रिक्ट कोर्ट से शुरू कीजिए तो ज्यादा अच्छा रहेगा। तो कुछ मिथ से जो आज के सेशन में क्लियर हुए हैं कि हमें सबसे ज्यादा जरूरत विलिंगनेस की है। अगर डायरेक्ट किसी को सुप्रीम कोर्ट में जाना है तो विलिंगनेस ही हमारी सबसे अच्छी चीज होगी जो हमें प्रोसीड करेगी। और ये जो डर है कि नहीं हाई कोर्ट या नीचे वाला कोर्ट ज्यादा सही है या हम अभी जा नहीं सकते, तो शायद हमारे बैरियर क्रिएट करते हैं जिन्हें हमें तोड़ना चाहिए।
बिल्कुल बिल्कुल, मुझे खुशी है कुसुम कि आपको सेशन आपने इतने अच्छे से उसका निष्कर्ष हमें बताया। जी, कल एक वर्कशॉप है गाइस, देयर इज अ वर्कशॉप टुमारो if you would like to attend. It's on a related topic. It's on, I'll just take you through the page as well. It's about setting up a successful practice. This is particularly for newcomers. How can newcomers set up a successful Supreme Court practice? It's a 3-hour workshop, 6 to 9 p.m. Right? Okay, is it advisable to pursue LLM for practicing in the Supreme Court? Aisha, would you mind attending tomorrow's workshop, because we are going to cover this aspect there. I would like to talk a lot about it, and therefore I think it's better if you come for the workshop. If you tell me you cannot, then I'll explain the answer. The senior advocates always say that it's not, but their own sons or juniors are LLMs. Wow, this is interesting. No, we'll cover this aspect tomorrow. This is an interesting point. Okay, who else? Is there any specific strategy to establish yourself as an advocate of Supreme Court? Lokendra, there is no specific strategy, it's, of course, but yes, we can tell you based on what has worked for other lawyers. We can tell you based on that. We're doing a 3-hour workshop tomorrow, looking at different trajectories, how you can do it. And of course, then it's your decision how you want to go about it. I hope I've answered your question. I'll unmute. I hope I'm pronouncing it correctly. Naimlim. You need to tell me how it's pronounced. Please go ahead. You can unmute yourself. Right, tomorrow's workshop's link. So first, let me share it. Having masters from an international university, would that be beneficial, or is there any disadvantage for practicing in high courts in India? There's no disadvantage as such for her if you have a master's from a foreign university. But what are the advantages, or there are no advantages? I think we are going to look at it tomorrow. So you can attend that. I'll try to cover whatever I can today as well. Let's see. Okay, let's look at the workshop page first. How to set up, how newcomers can set up a successful Supreme Court practice, right? So you can register from here. Okay, this is fine. So you'll get to know who is this for, etc. Okay. I'll also be doing webinars. So the webinars I'm going to do, this was today's. Tomorrow I'm doing another webinar. Sorry, tomorrow is a workshop. Day after tomorrow I'm doing a webinar on can I develop a Supreme Court practice if I do not live in Delhi. This is, I'm sure this will also be a question for many of you, that if you're not living in Delhi, is it still possible to develop a Supreme Court practice? So how many of you have this question in mind? You did, Aisha? Yeah. So many of you will. Therefore, we are doing a separate session just on this. Then on 6th at 4:30 p.m., I'm doing a session on what common mistakes do lawyers make while arguing before the Supreme Court. Please do register for these sessions if it interests you. On 7th of February, it's Court Craft at the Supreme Court, how to be effective before judges. So these can be very important if you're looking at establishing a practice in the Supreme Court, or at some point you would want to do it. How to become a renowned senior advocate at Supreme Court and what changes to be prepared for. For some of these sessions, we'll invite a senior advocate or a retired judge. We already had one with Justice Gora. If you would like to, watch it, it's on YouTube. How any district court or high court lawyer can assist clients at the Supreme Court without losing them. This is another question that people may have. How to manage a practice. So if you want to continue, or if you are practicing in the district court and you don't want to shift to Delhi, sometimes it can be just that you cannot shift to Delhi for some personal reasons, then is it still possible to have it? And if yes, then how can you do it? How can you continue to assist your clients? Because sometimes what happens, you just refer them to a Supreme Court lawyer and then you can't assist them anymore, even though you have handled their case all through. So how do you do that? These are the various aspects we'll be looking at. There's also a course that I have developed on Supreme Court practice, just to bridge the gap that I was telling you, the gap that people face when they come to practice in the Supreme Court, whether as freshers or whether they have practiced in other courts. Whether they have practiced in other courts, I think this is something that everyone faces when they come to Supreme Court. So I've just tried to bridge that gap. So sorry. How much does being a judicial clerk at Supreme Court help for future practice? This is another aspect that we will be considering tomorrow. We are going to do a very detailed session tomorrow. It's a 3-hour workshop. We'll be covering whether you should start as a clerk or judicial clerk, or whether you should, why can't I access it? Right, so we will be for some reason I cannot open this page. Wait. Yeah. Anything else you would like to ask till the time the page is opening? Okay, for some reason can't open this page. I'll figure this out, but this is the link of the page. I'll just share it in the chat box. This is the link to the course. For some reason, the page is down, but you can have a look later on. Otherwise, tomorrow when you're coming for the workshop, we will be taking you through what we're going to do in the course. Okay, anything else you would like to ask? I'll just stop sharing. Yeah, Namlim, is it okay for you to speak now? Do you want, you can unmute yourself. Anything else, guys? Yes. How did you find the session today? Anybody would like to share? Some of you have already shared you liked it, but other than that? Okay, useful, good. So see you tomorrow at the workshop, and thank you. Glad you liked it. Right. Yeah, I was very happy to see you guys today. Yeah. I hope you all are, I see you all in the Supreme Court soon, very soon. Thank you, Balaji. Thank you. So yeah, so hoping to see you all very soon at the Supreme Court. Thank you so much for joining. Thank you, guys. Thank you. See you. Bye. Bye. Adi wants to say something. Okay, Adi, go ahead.
Hello, madam.
Hello.
Thank you so much for the wonderful session.
Mhm.
What about if a student want to intern at Supreme Court? Can you guide us regarding that?
Right. So we have done an entire workshop on how to get internships under a senior advocate. So Supreme Court would mean either under a senior advocate or under an advocate on record, because when you do it with law firms, etc., they may not have many Supreme Court matters. They may have one or two. There could be lawyers who handle Supreme Court matters as well as NCLAT, etc., right? Because their NCLAT matters goes to the Supreme Court, so they handle that as well. So there could be lawyers with mixed practices. So you can either look for them, or you can look for a senior advocate or an advocate on record. For that, of course, you see, having these skills on your CV is definitely going to help to get internships. But other than that, of course, you need to apply. You can, once you're there for one internship, you can then meet other senior advocates and speak to them, right? Get an appointment. So there are various ways of getting internships, because there's no proper structure as such, even though every senior advocate would have somebody assigned to manage the applications, but they receive so many applications that if you apply sooner, it's better. So there can be waitlist period of 6 months or more than that. So it's better to apply before that. Even if you apply before that, if you have a reference, well and good. If you can find somebody who can, put in a good word, then of course that suffices for an internship, right? Other than that, so you basically need to keep applying, and you need to keep adding things in your CV. You need to, it can be anything. You can start writing articles. It can be anything. For internships,
Madam, yeah, are there any chances for the students to tag around with the Supreme Court advocates for like around a week or 15 days so
what do you
that
mean by
they can?
tag around? What do you want to do? Like, do you want it in proceedings? That's the intention of.
Yes, madam. Yes, exactly. To
Right.
observe the premises and the trial process and everything.
Right. So right now, of course, there are no physical hearings happening, and even the lawyers are reluctant. Mostly, we are operating virtually, right? So right now, you cannot even enter the court premises. You can enter the chambers, etc., and even that closes at 5 p.m. But beyond that, you cannot enter the courtrooms right now. So therefore, it won't be possible right now. But after that, definitely you can. Uh, yeah, I mean, you can write to me on LinkedIn, and that can be made possible. That's not.
Sure, madam. After I think after March onwards, as the proceedings are going to start.
Yeah. Kanishk, what are the sites where we can apply for internships? So for Supreme Court, you don't have sites. You have personal email IDs of the personal email IDs, as in official email IDs or personal, whichever they use for internship applications. So you need to find those. You can find them online. You can Google and find the email IDs and send it to the appropriate email ID that they use for taking internship applications. Some lawyers have a separate ID because they receive so many applications that, for example, Mr. Salman Khurshid would have a separate ID. So you need to find that out and you need to apply there. Otherwise, you won't receive any reply. Yeah. Anything else? But you can watch the session on there was this workshop we did on how to get internships and jobs under senior advocates. So you can, I think you can get some insights from there as well. Anything else? No. So we can call it a day. See you guys tomorrow at the workshop. Thank you.